So thank you again, and once again, good evening to all. So we have our next panel. So I'll be the moderating the session, and this topic is more about from impact of GDPR and other international data protection laws on Indian companies. And for this, I would like to call upon, as a moderator, I would like to call upon our speakers. So first, I would like to call upon Shivangi Nadkarni. She's an alumni of the Birla Institute of Technology and Science and IIM Calcutta, who is also a privacy consultant and a trainer. She is certified under several IS certifications, and as part of the ARCA consultants provides privacy and security governance and compliance management services. Her earlier experience includes working with SafeScript, the first licensed digital certification agency in India. Shivangi is a passionate trainer and is actively engaged in training in cybersecurity and privacy in India. Welcome, Shivangi. You're on mute, Shivangi. Thank you. So I would like to call upon our next speaker, Mansi Thapar, who is a global IT leader and also the ex-CISO of the Jaguar Group. So Mansi is a strategic planner and thinker with 20 years of experience in all verticals of IT, be it SDLC, information security, program management, operations, business and processes, or business excellence or analytics. She has prestigious certifications like PMP and Six Sigma Belt, ITIL, ISO 27001 Implementer, and PCI DSS compliance under her belt. She is engaged in planning and implementing information programs across the organizations. So GDPR application secretary are some of the key assignments that she has handled, and she is also on the advisory board of EC Council's case certification and has bagged many awards in the information technology and security space. So thanks, Mansi, for being here. Looking forward for the discussion.
Thank you so much.
Next, I would like to call upon Sameet Gambhir, Vice President, Corporate Law and Secretary, DCM Shriram Limited. Sameet is a senior corporate legal professional and a company secretary with over 2.5 decades of expertise in managing a gamut of matters related to corporate legal affairs, risk and compliance, company secretarial, brand protection, people management with a good leadership, team management, general management, and HR skills. Mr. Sameet has an extensive industry experience of over 27 years in different organizations, including KPMG, Hill and Associates, Schneider Electric, etc. He has been a member of National Committee on Regulatory Affairs, CII, member company law task force, etc. Welcome, Sameet. Looking forward for an interesting discussion.
Thank you, Rajesh, and thank you for having me here.
Thank you. So I would like to call upon next speaker, Mr. Nagendra Javagal, having 17 plus years of international and domestic experience in telecom, healthcare, and financial IT governance, risk and compliance management, information security, data privacy and protection, HIPAA, SOX, ITGC, and SOC 2, project management and policy standards. He's also a member of Information Systems Auditor and Control Association, ISACA, the International Association for Risk and Compliance Institute, USA, Healthcare Risk and Compliance Association, Scrum Alliance Organizations, Data Security Council of India, and also been a constant speaker at ISACA and BSpin Forum. He has several certifications to his belt, such as CISSP, certified 27001 lead auditor, HIPAA security and privacy, EU GDPR practitioner, Scrum Master, as well as the GDPR practitioner and risk manager, as well as ISO 9001 auditor and a business analyst. Welcome, Nagendra. Good to have you here.
Thank you very much.
Great. So, as we are all aware, the topic is more in terms of GDPR, which goes back to a legislation that has come in 2016, and it has made a very huge impact in terms of how it has not only shaped how the laws from a privacy standpoint or looked upon. It's also have made a tremendous changes to several countries across, in terms of changing their local laws and setting up a kind of a global standard in terms of how the law is being interpreted from a privacy compliance stand, and making sure that it has huge and major impact most of these countries. I mean, we saw the Malaysia, the Thailand law, which is much more in line with the GDPR. We also have the Mauritian law, the Dubai with some major changes. So we see much laws that has major changes. So my question to begin with, Shivangi, we have these lot of international laws such as GDPR, and but in terms from an extraterritorial jurisdictions, I mean, how they impact the way a business is carried out, specifically if businesses are carried out, say outside of the country, in a country like India, or with multiple presence. How do you see these laws are evolving and shaping the way how compliance has been carried out?
Yeah, great. Thanks so much, Rajesh. I think one of the biggest challenges of extraterrestrial laws is just, I think, to begin with, just comprehending whether it is applicable, in what form it is applicable to a particular organization. I've seen people struggle with even trying to figure out whether, for example, GDPR is applicable to them or not. And in a way, GDPR kicked off the whole concept of extraterrestrial in the context of privacy. Because until then, the general sort of understanding was, if I don't really have an office there, then where am I looking at? And now suddenly you're being driven by data subjects, right? And that gives rise to a whole bunch of complications, figuring out whether it's applicable. If it is applicable, what all needs to be done. And I think, especially in the early years of GDPR, there was a lot of confusion. Now people have settled down, but there are lots of interpretations and nuances which experts like you are able to, clarify from time to time. But just think about an organization, let's say, sitting in India, catering to clients in the EU, catering to data subjects in the EU, having to now suddenly worry about guaranteeing them, let's say, for example, data subject rights, right? How do you ensure you do that? Especially if yours is a business which maybe just 10% of your customers are based in the EU. Or how do you sort of manage your entire privacy program where you have one set of requirements for one geography, another set of requirements for another geography, and being able to put it all together so that as an organization you can cater to different types of data subjects are some of the challenges that customers face. I've also noticed, again, not in the recent past, but for example, when the GDPR was just coming in, that there are a lot of misconceptions as well. I still remember attending a few seminars where people would say that, hey, if a European national, for example, checked into a hotel in downtown Mumbai, then the GDPR is applicable. So there's a lot of those kind of misconceptions and wrong interpretations as well, which created a sort of scare. So I think overall, if you look at it purely from an individual's personal data perspective, the cross-border nature of these laws makes sense. But how that impacts organizations is something that everybody kind of struggles with, at least in the initial phases, till the clarity emerges.
That's perfectly great. So thanks a lot, Shivangi. I mean, I do understand, because this is there are several guidelines attached to it, but we don't still see there's a little more of clarity, confusion that does arise, and also from the appointment of representatives under Article 27 also adds to this some much my kind of a trouble. When you try to engage and where you see your law applies, but you are not part of that particular region. Thanks on that. So I just wanted to also understand, since we are from several industries, from several sectors, I would like to specifically try to identify and see in terms of when we talk of from a compliance, I mean, because compliance, you need to demonstrate the laws are making it much more mandatory and not you see the word shall more than may. And keeping that in mind, how are different industries trying to equip themselves to make sure that the compliance program that they do set, and while do the set, how did those organizations approach and stuff? So with this, I just wanted to start with you, Mansi. Mansi, since you are coming from a manufacturing sector background, uh, uh, can you just tell me how the organizations of manufacturing sector, where there are very limited amount of personnel, but much in nature, but still there's a rampant impact when there's certain breaches or incidents that do arise. How did you think of approaching it, and what are some of the challenges that you came across? If you can just shed some light without any disclosing any of your clients or other confidential details, if you can just give that kind of an insight, it would be great.
Sure. First of all, thank you very much and good evening to everybody. So yeah, you are absolutely right that manufacturing companies, when you look at it, you feel it is a mainly B2B companies, and maybe major customer data is not getting stored. But if you look at Indian companies, they might have some sales offices in Europe, having 5, 6, 10 people maximum. Plus, there are other manufacturing companies which also have plants in European countries or in other countries where now as you rightly said, privacy is now the in thing, and all the countries are, coming up with it. So the major thing in manufacturing is that privacy is secondary. First is security, right? Privacy and security, infosec go hand in hand. So that culture that, we are also liable for compliance where privacy is concerned was a major challenge we saw in departments, because the first question I ask everybody is that is privacy my responsibility, your responsibility, legal's responsibility, IT's responsibility? That thing is not clear, that who needs to own it. So the making people understand that this is everybody's responsibility where privacy is concerned, because compliance is going to hit the entire company, and that too on a global turnover. To getting that sentiment across was the biggest challenge. Second, of course, was that now where is the data line? Because then if you start looking at manufacturing companies, now maybe there is an HR. So in HR, they are now handling employee data, which is your personal data, right? So they might be keeping some copies across all systems, and they think that they are using a software for HR, but they are asking people for their passports or their Aadhaar cards, or in Europe they are asking them for their other personal details. How are they storing it? Where are they putting it? To explain that this is the inventory of things which we need to manage. That was the biggest challenge. So what we did was, first and foremost, we took management buy-in. That we thought that privacy implementation in the organization needs to flow from the top. Then only the seriousness will come. Second thing what we did was awareness before starting any program, that what are we going to do, what things they need to manage. Third was, what we did was, please find where is the data. And you'll be amazed that in manufacturing as well, there was a lot of personal data handling which we didn't know about. Like mainly in Europe and in other European countries, what happens is that you outsource mainly the payrolls, right? Because sometimes the companies do not know what all kind of legal things are there, and you have just taken a company and you have outsourced only the payroll part. Now then the processor comes into picture, which people don't think about. So these kind of data mapping exercises was a big challenge. So that is what we did: educate the team, create coordinators from each department. Every department to have a privacy coordinator, because see, at the end of the day, me being a security professional, you being a consultant, people coming in, but the business owners understand how the business is run, and where the gaps are. So it's always best to have an org chart in place, especially in manufacturing setups, that this is the person who's the owner for privacy in this department, so that he can drive with us and make us understand whether privacy is there or not. And fourth is, of course, privacy by design, as we all know. Now because in mostly manufacturing companies, you'll see a big IT setup where there are a lot of homegrown applications which are being working on. So vendor you can manage, right? You can send them clauses, you can send them how you are GDPR compliant, and because they're working with other people, they'll be compliant. But working with this team who's sitting inside, privacy was designed to explain them that this is what needs to be done, was a big challenge. And that, so we started educating them as well, that any development happening, that needs to be done. So I think that was how we managed. And fourth was, and which was the most important, is our customers, because our customers are now, like for us, our distributors are our customers. They are handling a lot of personal data. So if anything happens there, and they are working on our systems, right? We have extended our systems to them. So if they are working on our system, yes, they are responsible for it. We have all the signed clauses, but at the end of the day, brand name suffers. So if something happens. So now the fourth part, which everybody, especially in manufacturing, needs to look at is, are you educating your customers? Even in a B2B segment, that, this is privacy. Please ensure that this is happens. And the best part in most of the manufacturing companies now is that they have woken up to this, infosec and privacy things, because of a lot of ransomware and a lot of noise they are hearing, that manufacturing being the number 3 now in the target for hackers. So that has really woken up. Otherwise, earlier it was a very difficult thing. But last 3 years, I think the proactiveness is on the other side. They are asking us that what we can do. So that is a good thing. Yeah.
I think that's a one. So I don't know. Should we thank ransomwares or should we not? But still, I think
Yeah.
this is a quite a insightful one. So now from manufacturing sector, I mean, there's one other sector which is where you have a huge outcry because of the sensitivity involved, is the sector on healthcare. So my question is to you, Nagendra. So from healthcare sector, how do you see these challenges? How do you see the approach by organizations? And what are those some of the key hot things that you need to keep in mind while you're trying to address, and say ensure of a compliance in the healthcare sector?
Yeah, thank you, Rajesh. I would say one of the most highly challenging industry in US is healthcare. The reason is being the same entity had to comply with multiple regulations. On top of it, there is a federal law requirements. For example, if you live in Texas, they'll have to to comply with Texas Medical Privacy Record Act and also Identity Theft and Protection Act. Look here, same way it goes. Some of the entities are have to comply with Joint Commission standards. Some of them are go with the CMS, Medicare and Medicare Services programs or the regulations. Some of them are have to have the compliance towards their own state specific. Additionally, on top of it, they have to comply with HIPAA requirements. So here the complexity is so high that the privacy officer or the compliance officer, whoever is responsible for handling the privacy or security of the organization, he must be having reasonably good knowledge of all the different laws and security requirements applicable to those sectors. Of course, we may say that 80% of them are common, but the delta 20% or 25, whatever it is, that is a very key factor herein. So in each of these cases, the privacy officer holds accountable for compliance of all these regulatory requirements, ensuring that he meets all the statewide and relevant applicable laws also. Number two is execution of the business associate agreement, like we saw in the GDPR case, standard contractual clauses. In HIPAA law or in federal law requirement, there is something called BA agreement, business associate agreement. So keeping that business associate agreement, it's compliant and valid, stay compliant for the day, which is the most key important here. So many challenges are there that, because of lots and lots of laws being amended or changing or coming out with the new way of doing the things, this business associate agreement, which is there with the vendor or a third party processor in our context, wouldn't have updated or kept compliant for the day. So in these cases, for some reason, anything happens or any kind of a breach happens, there is no legal background for anybody for this matter. So keeping that business associate agreement with all the clauses which is recommended by HHS, Health Human Services under OCR, is very much important key over here. That way you can stay. There is a lot of challenges. Point number three is managing the regulatory changes. This is one more point I would like to mention here. So nowadays, very, very see that there is a pandemic. So because of this pandemic, there is a lot of changes is happening in the federal laws. So making sure that we assimilate those changes, put it to the operational perspective, understand what it is, what is the impact of this, how do we handle it. That is one more major challenging we have seen in the industry, Rajesh, in particularly healthcare industry between US and India operations. You're on mute.
Great. So lots much tractions. I mean, I think healthcare is one of the sector. Even when you talk from a US perspective, way back from 1970, it has been evolved so much. Based on this, the fair information pricing principles were also adopted. Thanks a lot, Nagendra. So now, to come back to Shivangi, one of the most interesting sector where most of our audience would be belonging to IT sector. Now, how and what are the typical cases, I mean, scenarios of approach that normally organizations do take? Uh, you can consider it from a global perspective, not necessary to look only from an Indian law perspective, but from a global perspective, how these organizations tries to adopt compliance with some of the laws like GDPR, LGPD, and POPIA, Dubai, DFC law number 5. So please share your views.
I think one of the, I would call, advantages of the IT/ITES sector is that it is mainly B2B in nature, right? So a lot of the challenges are equivalent to what Mansi talked about in the manufacturing B2B scenario, in terms of where since you're not dealing with end consumers, data subjects, the primary compliance requirements are inherited or come to you via contractual clauses, right? Which tend to be very, very stringent. And the more spread out your clients are, the more complex clauses and policies that you inherit via contracts as processors, sub-processors. And the challenge lies in being able to sort of, again, what I mentioned earlier, which is being able to put it together. So like you said, there is LGPD, there's GDPR, there's the US laws, there is Singapore, Hong Kong. Now, assuming I'm catering to somebody with data across these geos, then I have to come up with something which is like a common minimum thing, which is a holistic approach, putting it together and then adding on the nuances or the extras associated with every law, right? So sometimes that can be challenging, and therefore, you come down to having frameworks to implement that instead of directly trying to comply with laws at a individual level. I think one is that the holistic approach. Second, I've noticed with smaller organizations, small and mid-sized organizations, often because there may not be somebody senior looking at security and privacy in a dedicated manner. Sometimes they come up with this as it almost becomes a business emergency. So I've seen people working towards a deal, working for 6 months, 9 months, and then the deal comes to a point where it's ready to sort of close, and then it goes to the security or the privacy team, and suddenly there is like this, there's a roadblock, because then there's a requirement to go back and redo and look at policies, look at implementing basic measures before you sort of move ahead. So I would look at, even within the IT sector, the kind of challenges that the large organizations face are very different from the small and mid-size. And we have a very significant small and mid-size IT/ITES sector as well. So I think overall, one is that, crossing that whole understanding and comprehension and knowledge curve, and then being able to quickly do stuff, because it is a showstopper when it comes to business. You're on mute, Rajesh.
Sorry. Thanks, Shivangi. The information was very insightful, because these are some of the major challenges which a lot of times when corporates try to adopt a kind of a privacy program, and specifically that's the initial question to be asked in terms how they would like to manage this entire practice program. and adopting those laws into a practice. If it's a multi national corporation with a lot of global presence, and adopting to each local laws needs to be decentralized or centralized. I think this is one of the significant question. And thanks to all three. Now coming to so okay, now organizations have adopted the program. There are practices, policies, and procedures in place. Now, the next most important part is with regard to ongoing compliance of these laws. So, I would like now to turn to Sameet. Sameet, would like your experience in terms of what are those ongoing compliances and what are those things that organization should clearly focus on in order to stay a bridge in terms of compliance, that whatever the efforts that has been put and invested around is actually deriving the, the benefit that has been expected from the approach. So over to you, Samit.
Thank you, Rajesh. In fact, it's been now 3 years that the law enforce, and there have been a lot. We have talked about compliances and talked about the knowledge related sessions and all. So I think it was, initially the reaction or the action in the organization was that, there's another law which has come, GDPR, and we were even not aware of it, that, it directly impacts to us also. Because initially we thought it's a European law, and, we are not doing much. We don't have any offices in Europe, and we have no, then we realized that we have a lot of customers in Europe, and then, there are certain other things. Then we thought, oh, it must be a, privacy law. We have a lot of privacy policies and all, nothing to worry about it. And then, slowly when we realized and we came to know, oh no, this law has a larger impact. This law has an impact, like, you have to have the a lot of other things rather than only privacy, and particularly if you are dealing with the EU people, EU customers, etc. So then, we were actually doing that. Oh, a lot of things is to be done. And particularly when we saw the amount of the breach or the amount of penalties, etc., this really, this was really something which really make everything we realize, everyone know, it has to be on a very warfront basis. So then, as Mansi is right, it has to be the tone has to be set at the top, so then we realize that this is something which needs an attention from a very high level. And then, after that, we realize that what currently process and procedure we have for the data privacy, what else is required, how do you do that. And then 2-3 things which importantly we did was, one was, as Mansi also covered a lot of things on that, the data mapping. Data mapping was one of the foremost step that we have to realize, and we have to see that where the data is flowing, how does it originating, where it is flowing, where it is going, which department is involved in that. So all these things were gathered, and then we reviewed our current policies along with, so GDPR compliance. Then we realized first time that it's not a, number one, it's not a one-time project. Number two, it's not a one man show. That is where we need to form a committee. So we formed a cross-functional team of IT security, from marketing, HR, legal, and also risk management. We had internal audit and risk management head, and then all of us sat together, and then we decided to. So then the privacy policies were reviewed, and where all it required. And then the most important part we realized is that we need to make people aware of it first. So that was the first task, that only then you can ensure that there are compliances, unless people know about it. So first of all, tell them the definition. Who is a data controller? Who is a data subject? Who is a data processor? And then difference between the controller and the processor was also very important to tell them. And then we thought that, okay, now the people have no, and then we have to do all kind of trainings and workshops, etc. So making people aware is, I think, the key thing which I realized. And then thereafter, we should be able to do some control over that, they know what are the obligations. There is a lawful purpose for that, and what are the rights of the data subject also. Then they should know about the rights of the data subject. Then how do you do that process and all. So I think overall, initially it was it looked very difficult for us. It was but that's true that because we have a blessing of the top management, so immediately we can do a lot of things in that, and it was given a lot of importance. But actually it's not a, as I told you, it's not a one-time project. we keep on reviewing the things, we keep on, checking the things, whether it's something else is missing. And what do, fortunately, touchwood, there was no breach as of now, but what happens tomorrow if there is a breach? What should be the process for that? How do we report that? Should we report that to first our internal, this and all, and how do we handle that breach? So all these things are taken very seriously now. So I would say that training and awareness is one of the key factor in the ongoing compliance. Plus, a lot of other things, like how do you should have a complete system that if there is a breach or something, that you have to make people aware of it. And then certain things were done by IT people, like adjustment of their website, cookie consent, and etc. Or how do you manage that? I think e-privacy is also coming now. So is that something which is that something that is in line with those which are coming, the prudence and all? But yes, there were a couple of other issues. Then we thought that let's do assessment or monitoring also. So we got a assessment and monitoring or an audit done by a third party agency, so that we know how much we are, up to what extent our policies are good and we are comfortable with that. And then we realized that after an audit and assessment, we realized that up to some extent we are strongly covered, and people have really understood. And they also they also told us that up to what extent you are, so industry practice case of the manufacturing, your kind of industry, where do you stand, kind of a thing. So these are the things we did initially, and we still continue to do all these revision, review, impact assessments, etc. I think so these are the things, but training awareness was most important, I would say.
Rajesh, you're on mute
You're
again.
mute again.
Okay, I think most of the times training and awareness is always a factor, because even though we say that it needs to be done at a very frequent intervals, I think the way the frequent has to be defined as much more. It should be more daily or weekly manner. I think that's one of the key factor, and that's where something most of the times, the impact is on where, because with the words laws like GDPR, where in a personal data breach, even an accidental breach also ends up with a huge penalty. Now, coming back to another one of the basics, I'm sure this would have been discussed in some of the conversations in several other forums as such. Is much more. I would like to still bring it here, since we have esteemed panelists, uh, on the legal basis of processing. And this is something which is always quite, not clear to what should be the legal basis that needs to be adopted. We see organizations, something which are, one of the big fours, getting penalized for not using the right legal basis by one of the authorities in Europe. So, Shivangi, I mean, I'm just getting back to you in terms of, uh, is the consent only the viable option, or do we see different legal bases which can be adopted in the context of how a business can be established? I'm not bringing in the concepts of where there's a lot of clarity of confusion that is arising between GDPR and e-privacy in letting whether a marketing can be an opt-in or it can be even a legitimate business interest. Let us leave the marketing a little bit aside, but from a different generic data processing activities, how do you see how these legal basis of processing the concepts, and even in the pandemic age, how this has been adopted, and what are those challenges that we potentially see as kind of privacy practitioners when we implement some programs?
Yeah. I think first of all, many people are having this perception that consent is the only legal basis on which one can process data. So I think all of us as privacy practitioners have to understand that processing of data has to have an associated legal basis, which one of which is consent, which in most laws is a very large way of obtaining consent. But understand that there are other legal bases as well. In my head, I kind of separate out legal bases into two buckets. One is what we like to call BAU related legal bases, basically legal bases that are part of your conducting business. So, for example, consent, or let's say employee contract, which is what was proposed in the India PDP bill as well. So, any of your employee this thing, you don't have to go out and get consent. You can use employee contract as the basis. Or like in the GDPR, you have legitimate interest and so on. And each of this has nuances. So as you said, not getting into that. Then you have an entire set which I would call as the non-standard but business related. So for example, examining network traffic to detect fraud, you don't have to go out and get consent for that, right? Although there is personal data being observed in that, because that comes under fraud detection. For example, the PDP bill supports that. There are a whole bunch of clauses in which you can process data for certain exceptions in courts, which can be used to run your business in a certain manner. And then there are a whole bunch of what I call non-BAU, or rather non-standard processes, which come in as exceptions rather than the rule, like national interest, vital interest, in the interest of the community. There are different terminologies used in different laws. So, for example, when the pandemic hit, there were a lot of questions on what basis is details about my health status being taken. A lot of it was done under the legal basis available, which was not consent. So I think, first of all, just be cognizant of the fact that different laws allow different bases of processing, and only thing is, make sure that every data and the purpose for which the processing is happening is associated with a certain law. So, for example, if we go back to the same example of using network traffic monitoring. Now, monitoring network traffic for fraud detection as the purpose can be used under one legal basis, but monitoring that for tracking and profiling a user is certainly a different kind of purpose, and you need a different legal basis to process that. So I think having that understanding and building that understanding while implementing a privacy program is very, very critical to make sure that you sort of balance the business requirement and ensure that the end user is not inconvenienced. At the same time, you don't transgress the law and cause harms in any way.
Thanks a lot, Shivangi. I hope now I'm not on mute. Okay, so I just made sure that I
Yeah.
have it totally.
Yes, you are not.
Yeah. So, another one of the interesting point, which I'm sure, is something which you also see in the PDP, and this has been evolving. The terminology or the concept that was, devised by Dr. Ann Kevorkian, which is the privacy by design, which in 2010 was adopted as one of the best practices by the DPO commissioners who met in a particular conference annually. And now in GDPR, you see that as one of the legal requirements. Even in the PDPA, we talk about this also mentioning about privacy by design, even though whether it's terminology applicable or not. But in an organizations to see as part of either of the local processes, or in terms of solutions, or in terms of from an extended enterprise adopting a third party tools and implementing as part of the day-to-day organizational needs, how privacy by design is something which is is a requirement, and the obligations primarily on the controller, which has a penalty also to 2 to 4%. How are organizations trying to adopt that? So this question is to you, Mansi and Nagendra. So Mansi, if you can begin with, your views, points from a privacy by design, and how it applies, and what are some of the challenges around that?
Yeah, so you are rightly said that, for compliance, privacy by design is something which is very important. But I would say that privacy by design is the core of, all privacy laws, if you see it. The basic explanation of privacy by design is little more than, data protection through technology design. Privacy by design seeks to deliver, I say, maximum degree of privacy by ensuring that personal data are automatically protected in any given IT system or business practice, right? So what I could gauge was that privacy by design works on mainly 7 principles, right? One is be proactive and not reactive, right? Privacy as a default. Privacy embedded into the design, full functionality, end-to-end security. And what was next? Yeah, so visibility and transparency. And the last, which is most important, respect for user privacy. So if you look at this, and so the entire privacy laws also, right, really revolve around this, right? So privacy by design, and let's take some examples like, DPIA is privacy by design concept. Providing contact details of your DPO or other responsible parties proactively on your websites. That is privacy by design. Writing a privacy policy that is to read and keep you up to date for your customers or anyone who's coming on the website. So these are some things which shows intent of an organization, right? Which helps and goes a long way to even convince the auditors that I have an intent. That is why I have a privacy by design policy. I have a privacy policy in place. I have a DPIA in place. So these principles, along with if you are working together and having that culture in the organization, again I'm coming back to the culture, that privacy by design is really required. I think you're half of the battle to implement privacy as a compliance is one. So privacy by design means, considering privacy from the beginning of a project, integrated into your systems and operations. It is not a security practice or tool. Most of the people think that, it is a security thing which you need to implement. No. Getting it right means encouraging an organization culture dedicated to acknowledging and respecting the value of personal data, both to your company and to your customers. So it has to be, not a compliance thing, but something which the company wants to do. And if that intent is, that is the intent, right? Intent is something that you want to plan. And that my intent is there to plan privacy by design. And if you do this, I think compliance really is an afterthought. Then you don't need to worry about it.
Great. Nagendra,
Yeah,
would like
Rajesh.
to add something?
Yeah. So I agree what Mansi is mentioning here. So one more challenge I see that here, privacy by design, I agree that we'll have to design in the initial stage of the SDLC, I agree. The point is, still in US, many of the entities or organizations they're running on the legacy applications. They have huge volume of data. They are finding very challenging to comply with today's cloud environment and different environment. They are finding very challenging. So here they are trying to retrofit some of the applications, but still there is a gap in the integration of all these databases, all these different architectures, SDLC process. That's the reason Health IT, as a part of HIPAA Act, they have constituted kind of a division to do research, develop the necessary privacy and security different controls, which can be adaptable across the healthcare entity. You can take a look at it, high trust framework or cybersecurity framework. These are the different frameworks that can be adapted there to manage to different compliance and security requirements, it be it a state level, by it a federal level, it can be very much compliant. Number two is ONC, Office of National Coordinator. They have dedicated lab which will, and also dedicated accredited bodies which will evaluate different ID applications, and also they will get some sort of the compliance and assurance report. Yes, this product or this application meets minimum standard or expectation and the conformance. So that's where nowadays it's happening here, Rajesh.
Thanks a lot, Nagendra. So I see Summit got dropped off, but still, one of the obligations, one of the area that says pretty much I covered it as part of my keynote speech, but however would like to cover it here in terms of when we talk from a cross-border data transfers, in terms how is this new Scrums 2 having a major impact on the business, and is it really making an impact specifically for Indian companies, and any of the supplemental measures? I mean, Shivangi, if you can provide some kind of input.
Yeah. Sorry, I'm in a very noisy place suddenly.
No worries. You can
Yeah.
enjoy the birds singing there. That's fine.
No. So I think Shrems, first of all, so go back to the very basic, which is, we always say, like in finance, follow the money; in privacy, follow the personal data, right? So very clearly, with all the discussions around SHREMS, we need to understand that it is specific to personal data flows between the EU and the US, not even vice versa, right? So if you are in a situation in your business where you have personal data from the EU flowing into the US, only then are you impacted by SHREMS. Otherwise, and with SHREMS judgment coming in, which annulled the existing framework that existed, privacy shield between the EU and the US, the US went back to being yet another country for the EU, just like, say, for example, India is. And therefore, whatever instruments are available for, let's say, transfer of personal data from Europe to India, same thing is applicable to the US. And I think we'll have to just wait and watch. You were talking about SECs, and that's, which is one of the very big instruments available. Or if you're looking at end users, then there is direct contract or consent also available if you're in a B2C kind of environment.
On the supplemental measures, how do you see? I mean, Nagendra, please pitch in. The requirements of encryption, and since if you see most of the engagements that Indian companies provide are majorly the outsourcing service providers, so definitely they do have access to data, but most of it we potentially see through a remote desktop. Do you see a potential impact from a scrums to, from an Indian law perspective? I know there was a report that was also issued by FDPPI 6 months back. Also, recently, the NASCOM conducted a survey and also published a report where probably Shivangi, you were also playing a major role there. So, are we seeing any kind of major impact from the Indian outsourcing entities and in terms of the clients demand a huge amount of supplemental measures which can really override the cost from a commercial standpoint? So, any such impact, anything that probably which you would have heard about it, or something that which you'd like to share, and what could be the solutions that can be put in place in terms of handling those kind of cases? I mean, if that's something which can share some insights. Both
I
Question is
haven't.
Shivangi and Nagendra, either of you. I mean,
Nagendra, please go ahead first.
yeah. Nagendra, I think she has asked you to go ahead.
Yeah, okay, thank you, Shivangi. So I haven't seen such instances wherein it could be bad impact, because the reason is pretty much all the outsourcing companies who are there in India, they do work with virtual clients. Obviously, the data or personal data or patient information do not travel right from US to India. So they stay there only. Only the view will happen here in India with their IT infrastructure, but they do not travel. So from that perspective, I do not see any kind of a much impact happens in the Indian operations.
Yeah, but under the processing definition under the EU GDPR, viewing is also processing, right? So automatically that's where you have your DPA as well as SEC continue to apply. But is this the context that we can assume that in case of remote desktop where there are appropriate controls in place where you don't set the data stored in any of the India systems within India or within the Indian soil, and thereby the laws that are in place, I mean, we do have a lot of surveillance based laws, but these laws doesn't have the jurisdictions to claim, because the data, the extent at which they can request for data is the data which is controlled by an organization which is processing. And since probably we are not storing it anywhere locally within the Indian systems, does it safe to assume that scrims has a very low kind of an impact for organizations in India?
Should I go?
Yeah, go ahead. Go ahead.
Yeah. So, see, the organizations in India, as you rightly said, if you're working off a virtual machine, while it is still considered processing and therefore will come under the ambit of a privacy law and or of data transfer across borders, I think when it comes to actually implementing controls to handle that, the cost associated with that will be minuscule, in the sense that while you will have the SECs, or the, if you are a company which is in a group, a BCR, or in some other form, you may have to sign those contractual terms. But as a result of that, as a small organization, what I need to do, those controls and those activities may be minimal because I'm not downloading data. So I may have to put in terms, I may have to put, like I've seen a few companies where, despite having very clear policies that individual employee should not download and store data on the local machine, people still tend to do that, not with a malicious intent, but to sort of make, convenience portions. So in that case, there could be other control measures. But as you just mentioned, implementing encryption, implementing other kind of high cost systems may be completely avoided because you're not really downloading data. So I would actually look at it from an entirety perspective rather than just look at it in terms of applicability of the law. It's what is the result of that applicability is what one should focus on.
Great. I mean, that's really a valid point. Thanks, Shivangi. So with this, I just probably thought, since we are coming to the end of the session, there are some few questions. Probably I will. I think Ramesh. I hope I, as a moderator, can read the questions.
Yes, Rajesh. Please go ahead.
Okay.
You want me to read? Otherwise, please go ahead. You will be
No,
the best.
that's
Go ahead.
fine.
Go ahead. Yeah. Thank you.
So this is a question by one of our audience, Reena, who was just asking, I mean, do you believe implementation of privacy laws will work effectively, whether it is a top-down approach or it should be a 50-50, both top-down and bottom-up approach to achieving compliance? Please feel free to anybody to jump in, and probably I can also jump in with my own views. But
I would say that, Rajesh, it's all depends on culture of the company, management, how their commitment towards compliance towards the privacy, and also their counterparts like data controller or covered entity, whoever is responsible for making sure that their commitment is there to make sure that their business is also safe. It has a multi-factor kind of a compliance requirement, Rajesh.
okay. I was just going on with that. The one word actually gave the response. Culture. Yeah. Shivangi, you would like to add anything on the top of that?
No, I think what he said was true. I think in the culture itself says whether top management directive and interest is not there, uh, project will completely not take off. It cannot be something which is initiated at the middle management or bottoms up. That much is guaranteed. I've seen examples of happening on both sides of super successful implementations because the word has come right from the top, and not happening because the senior management is not very interested. So but the actual implementation, to come back to Reena's question, yes, a lot of on the ground, many foot soldiers required to implement, but direction has to come from the top.
Yeah. So it's Reena, mostly it should be from my end, it would be more of a 50-50, because you need the top-down directions to be there, but at the same time, it's the employees or the subcons who are involving on a day-to-day transactional processing needs to make sure to understand the roles and responsibilities that they play in adhering to the requirements. I still remember Mr. Navi himself. There was a beautiful article published where each employee should be his own CISO, because as long as he is or she understands the current roles and responsibilities, I think preventing any kind of security flaws is not easily approached. And humans will always we will go with the saying that humans will always continue to be the weakest link. And that should be the only constant thing that we will have in first. Thanks, Reena, for that. So I have a question from Narsinga Rao. So this is more from in terms of your own expertise. That have you seen something like? Are there any software tools which are used in the industries to implement data privacy? Are there any robotic process automations deployed? Even though we can't go ahead and recommend anything, but is there something that, do we have something in the market as on date which can manage any of its privacy day-to-day practices? We are not talking from a overall governance GRC structure, but we are looking from any software, other tools that can play on a day-to-day role.
Yeah, plenty of tools. In fact, the IPP website IPP brings out almost a quarterly or once in 6 months a vendor report on all the possible privacy related tools and solutions available. It's a good idea. It's freely available to download, and that's something which you can refer to, because there are literally tools and automation available for almost every kind of need that a privacy program throws up.
Thanks, Shivangi. Nagendra, would you like to add anything?
I'm good, Rajesh, for now.
Okay. Okay, another question is from Pramod. One is his view, other one is his question. So his view is as part of the privacy by design, where the most of the people working on the projects are from a technical background. So the project managers are not aware, and as well as ignore saying that we do not have access to the production or live data. So where we see most as a challenge, and right seniors from the organization should educate the technical force. So yes, that's correct, Pramod. But follow up to your question is also sometimes DPA are in line with what project is doing and need to fine tune the DPA before signing such DPA with customer. Do you literally see that this is something which is happening? I mean, what is contextually that has been signed as a kind of an MSA or a DPA? Is that getting literally translated to the project team with what? Uh, are they really focused on things which are outside the scope of technical requirements? Do you see that as really as a good practice that most of the organizations, their team members do perform? Any experiences? Navi sir, you can also pitch in, sir. I think you would have much more insights into this.
Yeah.
Just sorry, as a moderator, taking the privilege to loop in.
I would say, in the earlier example, we talked of one word culture. Similarly, here I would like to use the term maturity of the privacy program in the organization. The more mature the program is, the more people are empowered, and processes in place to ensure that if there is a DPA, how does it translate to, let's say, a project manager in this case, and vice versa.
But I would like to add to this, Shivangi. There also must be a techno-legal consultant, who understand technology. I'm not saying you be an architect. I'm not saying that. At least a legal person who deals with the privacy requirement, if he can have the reasonable knowledge about how IT works, how application works, how a server works, what is the cloud services, if we can understand to an extent, that make really sense. That way we can integrate legal as well as IT into one bucket. That's what I see. For example, tomorrow a lawyer should demonstrate how the encryption works. How do you authenticate that yes, really this is an encryption? If we can have at least reasonable knowledge about that, which he can tell his own words, that way it is very helpful for organization also. They'll translate into the IT requirements. That way it can be implemented. That's what my opinion is all about.
Good
But
insights.
you have folks like Rajesh playing such a critical role in your this thing, right?
I do my best, but Navi sir, yes, sir. Please, we would like to have you back into the game, sir. You have any insights that you would provide in terms of, probable insights that project people work? Are they really the requirements that are there, the DPAs and stuff, are they really translating on a day-to-day operational requirements? Or is it just focusing more on the technical engagement standpoint? So any insights and inputs from your end, sir?
You're asking me?
Yes, sir.
No, I didn't get your question fully. Please repeat.
The question is, we do have contracts.
It's breaking, Rajesh. I don't know. It might say.
Voice is breaking. Yeah.
It's breaking, Rajesh.
Okay, so am I audible right now?
Yeah, audible. Yeah.
It's
So
chopping
what I'm
off.
saying is, we have MSAs, we have DPAs with privacy obligations.
Yeah.
When project team members work on a particular engagement, SOW, these aspects are not getting appropriately translated, as highlighted by one of our audience, where the real concept of understanding the technicality or the legality of a particular privacy requirements on a day-to-day operational is not sufficiently found. Do you see that as one of the major challenge, and what is your insight? Because as Shivangi and Nagendra did say, culture is one of the biggest issue, and awareness is one of the thing which it needs to be. So your input, sir, because this is your stronghold, which I know it. So that's why I thought let me force you
No.
into.
Obviously, this is, as Nagendra put it, technology and law should be simultaneously assimilated. Now, what we have actually been promoting is that it is not possible to implement data protection by having one single DPO sitting somewhere. We need to have distributed responsibilities at levels where the technology is working. That is, whoever is nearer the process, he knows what kind of data is coming in or how it is going out in the process. And the compliance officer or anybody else who may be an expert in GDPR or something, he still doesn't have the feel of what is going on in my own company. See, our own company is so big, and there will be multiple people who will be drawing up their own Excel sheets, their own processes. They are doing a lot of processing without it being standardized kind of a thing. So distributed responsibilities is essential. If you have got a project manager, the project manager should be made responsible for data protection in his project. If there is a unit manager, that unit manager should take some responsibility for the unit. DPO will, of course, be there. Externally, when you want to meet the supervisory authority, the DPO will represent the company. But within the organization, he needs complete support from different, say, process owners. Okay. And how you distinguish, I mean, logically make your teams, that is left to each particular company. That is, I think, what is the key: the distribution of responsibilities nearer to the process and making them understand law as well as the technology is the essential feature.
Great, sir. Thanks for it, sir. I have two last questions. I'll just quickly run around. One is, Rina's question again, that in your experience, okay, it's a personal, is a vendor compliance a high risk area for achieving? Any experience, Shivangi, on this? Is vendor compliance for vendor, is it really a high risk areas? Is it something that you can normally achieve, or is it something like a myth?
It is hard to do, basically because there is only so much of control that you have over your vendors. For example, trans border, I've seen in quite a few cases where within the organization you've mapped all your cross border sort of flows, but if your vendor is sending cross border, then that's something many times comes as a surprise. So things like that. So overall vendor compliance is hard, but my advice is first focus on fixing your house while you try and figure out, at least get data flow maps of your vendors when it comes to your data, so that you have some sort of control. And I'm assuming that you have a very good cybersecurity risk management for vendors as well. Align all the privacy pieces with that, but it is not easy to.
Great. Thanks a lot. And I think thanks, SK Prakash, for the general mantra. Compliance is not one's responsibility, it is the responsibility of the team handling the subject matter and is closest to the process. Thanks for echoing the thoughts of Navi. The final question that I think we have almost come to the end of the session. So there's one question, and probably I think this needs to be directed to Vijay sir and probably Shivangi, if you can pitch in. A question from Ali: how data privacy can be managed in a bank? What are the various legal compliance in this regard? And further, to improve data privacy and of customers and stakeholders, is there any exception prevailing in Indian territory? I don't see an exception, but still, Any inputs, any thoughts on that?
See, bankers handle not only data of Indians in India, but also their NRI customers. So they will be sometimes exposed to multiple data protection laws. Other than that, by previous practice itself, bankers have always been aware of confidentiality. We were not calling it as privacy, but confidentiality and the information not to be revealed to anybody other than the account holder. This was something which is well ingrained in the banking system even before the digital banking came across. So as far as the culture in the banking organization is concerned, confidentiality is there. Okay, so we don't, I was a banker, so I can say that we never used to reveal the information about one customer to another. And even when balances have to be revealed, we were, at that, those were the ledger days, we used to write it in a slip of paper and hand over, not voice the balance. So this kind of awareness has been there in the bank for a long time. Rest of it in digital banking, there is not much of a difference between banks and other places because we use almost similar types of applications and other things. I don't think much difference is there as far as the banking sector is concerned. Now RBI has got its data localization and other sectoral regulations. Right now this DEPA has come. Now that is something which is very interesting because this is a consent management architecture which the Reserve Bank of India is rolling out, where there will be a consent manager who will have, say, consents from the customers. So he will have a customer related service. And then there will be one data provider who is the bank, who has got the data of various people. Then there are data requesters. So this account aggregator, who is a consent manager who sits in between the customer on the one side, data provider and the data user on the other side, and tries to act as an exchange of information, with the difference that there is no visibility for the private data. That is, he doesn't know whose data, what data is flowing, except that he has a client. But the data which flows, for example, if somebody is asking what is the bank statement of account for the last month, now that is flowing through the system, is not visible to the account aggregator. He only facilitates it like an exchange, which is a good concept. It's a sort of a data exchange service which is being introduced by the Reserve Bank of India, and this is going to be extended to health sector as well as telecom. So when these three comes, we are going to have a technical, you can say, architecture available for personal data interchange. I think that is something which the bankers are innovating at this point of time, and maybe that is also useful to the data controller, data processor and sub processor like that. We can actually build in a system where processing happens without one intermediary not having visibility to the identity elements of the data. So I think that is something which bankers are contributing to this system of data privacy at this point of time. Okay, Shivangi wants to add anything? You can.
Yeah, I'd like to add based on what I have seen across many of the banks that I have worked with. I think one of the biggest challenges that they're grappling with in terms of a privacy program is what is called using of data for a purpose which the user has not consented to. So while the basic culture, as Navi sir said, is ingrained in banking, which is that you will not share, let's say, give a bank statement to somebody else, but within the bank a lot of data is repurposed for analytics, and which is again used for marketing and so on, which is so evolved and so mature in some of the larger banks that to be able to separate out and restrict usage of the data to the purpose that the user has given her okay to is a huge challenge, and it's a problem that's going to take some time to sort of untangle and cater to. The other problems that I've seen is catering to multiple jurisdictions from a single sort of architecture. So let's say, for example, FD as a product, right? Usually a bank will have a single application that caters to all their customers of fixed deposit, but that is, let's say, spread across 22 jurisdictions. Now, what does the product manager or the business head, how does she manage that app, that entire product, so that all the nuances of all the jurisdictions are taken care of, and therefore coming up with that common minimum thing? Those can be challenges. The third is cross border, and the fourth is vendor risk. You do what you can, but there are so many vendors today that a bank uses, that to be able to figure out what is going on within that larger group is a nightmare. So typically banks, I would say, would take at least 2 to 3 years at the minimum to really get a basic privacy program off the ground at the implementation ground level.
Thanks, Shivangi. Thanks, Naisa.
Yeah.
So, thanks again for the opportunity. Thanks to the panelists. Sameet and Mansi had to step in out, but Nagendra, Shivangi, thank you very much. And as always, thanks, Navi sir, for sharing your inputs. That really makes the insights much more powerful because of the clarity that you provide on the topic. So, thank you again, and it has been a great. And over to you, Ramesh.
Thank you very much, Rajesh. And